Morning, ladies and gentlemen. Welcome to today's webinar on data regulations in the UAE. We'll be starting this webinar in about 5 minutes. If we can just ask for the panelists to do an audio check, please.
Hi, good morning, everyone. This is Sakina.
Thank you, Sakina. Madan? Good morning, everyone. Thank you for logging in to today's webinar on data regulations in the UAE. We'll start the webinar in a couple of minutes. If I could just ask Madan to do an audio check, please.
Hi, good morning, everyone. Madan here.
Thank you. We'll start in a couple of minutes. Thank you. Good morning, everyone, and again, welcome to today's MBG Corporate Services webinar on data regulations in the UAE. Next slide, please. Today's agenda, I'll be giving a brief overview of MBG Corporate Services, and then I'll hand over to Sakina Dikinwala, the Director at Legal here at MBG, who will give an insight into the legal aspects, followed by Madan Mohan, who is the Director of Cybersecurity and Data Governance. We'll then have a Q&A session, so please do submit any questions you may have. We'll see how the time's going and we can answer all of those. If not, we'll always get back to you in person with any questions and any answers that we may have following your questions. Next slide. Next slide, please. So just by way of introduction, for those of you who are not familiar with the group, we've been around for many years now, established in 2002, have a presence with 16 offices across 6 locations, typically high growth markets, such as Europe, Middle East, Africa, Asia, and we have over 3,000 clients globally. I'm very proud to service over 100 of those, which are Fortune 500 companies. We have over 450 staff across our offices within the network of the group, and all of those staff are employed by MBG. We do not outsource any work. Next slide, please. Next slide, please. Part of the unique offering that MBG has is within our network, we have dedicated foreign enterprise teams that will support organizations from their native country. So in the UAE, for example, we have a dedicated Arabic desk, obviously, a fully fledged Arabic, Chinese, Japanese, and European desk. So this will support the technical, linguistic, and cultural barriers that organizations face with cross-border transactions. Next slide, please. As an organization, MBG Corporate Services will support companies wherever they are in their life cycle. And we have these services that enable us to do that, be it from the company setup or even pre-setup with the legal requirements, through the growth stage, shakeout, maturity and extension. And obviously during this time, we're supporting a lot of clients who are going through challenging times and supporting them with various steps and services, which I'll cover later on. Next slide, please. So as part of our service offering, we have the audit and assurance, taxation and risk advisory, which detail many services, some of which we've included on this presentation. If we can just go to the next slide, which will detail some more of the technology and legal side. So we have the mergers and acquisition, the legal advisory, which is represented by Sakina today, strategy and transformation, which bridges all of our departments, and the technology advisory service, which Madan is representing today. Next slide, please. So we have, as I mentioned, been responsive to the market, providing a lot of COVID-19 specific related services. And this is in response to the market. We're taking our feedback from our customers, and this is what the market is requiring, and we've been happy to provide that and provide this service to our customers to support them during this challenging time. Next slide, please. So as an organization, we have all the affiliations you would expect. from a firm of our stature. From a government perspective, we work very closely with the federal authorities for the Unified ICV program, work as a registered tax agent with the Federal Tax Authority, and work and registered with all of the main free zones in the region. From a bank empanelment point of view, all of the main banks we're empaneled with here in the UAE. Our partner network is diverse, from robotic process automation through to taxation and legal services, through to chambers and trade bodies, which we take and give feedback and seminars and webinars to those organizations. Next slide, please. So just to introduce the next speaker, Sakina Dikinwala. Sakina, I'll hand over to you. Sakina's been with MBG for many years, has a wealth of experience in the legal department. Sakina, over to you.
Thank you, Oliver. Once again, good morning to all of you. So let's start with the topic. So currently, as the UAE does not have any comprehensive data protection law at a federal level, however, there are a number of laws in place that governs the privacy and data security in UAE. Also, data privacy or protection of personal data is in fact addressed in numerous provisions across different laws and regulations. There are some sector-specific data protection provisions in certain laws. The UAE also has a number of special economic or sector-free zones, 3 of which have specific data protection laws. This consists of Dubai International Financial Center, Abu Dhabi Global Market, and Dubai Healthcare City. So now let's discuss some of the federal laws under which the protection of the data has been given. Next slide. So some of the laws are being covered here. Let's take firstly the cybercrime law, which is one of the most important regulation which relates to combating information and crimes, and which comes under the purview of Federal Law Number 5 of 2012. So the cybercrime law protects the privacy of the information published online, including data, information, credit card numbers, bank account statements, and details of electronic payment methods. It further expands the definition of the conduct violating the privacy of others by criminalizing transmitting, disclosing communications, taking photographs of others, copying, saving, or publishing them, and publishing news, comments, statements, informations, even if they are authentic. So basically, it provides number of penalties which are being covered under the cyber crime laws, and this could relate to the activities such as gambling activities, materials that prejudice the public morals, then defamation, contempt of religion, human trafficking, harming the national unity, promoting demonstrations without a license, etc. So there are various topics that has been covered under the cybercrime law. Now let's talk about the data protection law in DIFC. So DIFC has recently issued a data protection law, Law Number 5 of 2020, which has replaced the current regime. The purpose of this law is to provide an enhanced standards and controls for processing and free movement of personal data by controller or processors, and to protect the fundamental rights of data subjects. This includes how such rights apply to the protection of personal data in emerging technologies. The law aligns DIFC's data protection landscape with measures adopted globally, such as GDPR in the European Union and California Consumer Privacy Act in the US. The goal is to establish and enhance governance and transparency requirements that will place the DIFC on par with the international laws and regulations. Also about the DIFC data protection law, the details will be covered by my colleague Madan in the next session. Then let's move to the data protection regime in the ADGM. So ADGM implemented a data protection regulation in 2015. These were subsequently been amended by data protection regulation in 2018. Under the regime, ADGM registered companies are imposed with specific obligation when they are collecting, storing, processing, and transferring the individual's personal data with the aim of protecting the right to privacy of the individuals to whom personal data relates to. As a general principle, a duty to any information which is being processed by means of equipment operating automatically or is recorded with the intention that should be processed by means of such equipment likewise. The definition of personal data has been refined to explicitly include individuals' criminal record, making it more consistent with the similar definition in force under EU regulation. And the data export provisions has been rephrased on the other hand by expanding the list of the jurisdiction offering an adequate level of protection. Now let's talk about data protection covered under the civil code. So basically any wrongful breach of privacy that may result in a civil action for damages pursuant to Federal Law number 5 of 1985 pertaining to civil code. The civil code also provides that a person who suffers for any unlawful infringement of any of the rights granted to him, then the person has the right to for such infringement to cease and to claim the compensation from the authorities. Further, any wrongful invasion of the rights to privacy under the Constitution may constitute a wrongful act pursuant to the Civil Code, and that gives a right to claim civil actions for the damages. The Civil Code provides that any harm done to another person shall render the perpetrator liable to make the good the harm. Given the importance attached to the concept of good name and the right to privacy in relation to the personal matters in this jurisdiction, we are of the view that any harm that could be held by the courts to include damage to reputation and invasion of privacy. It is also important to note that because of the wrongful conducts of this kind of nature, it would not result in physical injury. A valid claim for compensation may only be applied to the extent any wrongdoer had been acted with intent. So basically, if there is no intention to do a wrongful act, then that person could not be held liable in several cases. Next slide. Now let's talk about some of the telecommunication regulations which has a provision containing the data privacy. So Federal Law, Decree Law number 3 of 2003 covers organizing the telecommunication sectors that states that any person that copies or discloses any communication may be subject to a fine or imprisonment. The UAE Telecommunication Regulatory Authority, TRA, Consumer Protection Guidelines states that the consent of the subscriber must be necessary to obtain before a communications company may share any of the subscribers' information to an affiliate or third party. So this clearly means that if the consent has not been obtained and if the telecommunication companies are sharing any personal data relating to its subscriber, they may face a heavy fines and also the imprisonment. Let's move to the electronic transactions and commerce. So Federal Law number 1 of 2006 governs the electronic transaction and commerce that has been implemented mainly to protect the rights of the individuals conducting business electronically, also to minimize the incidences of fraud that being done due to electronic communications, and establishing the rules to regulate the authentication and validity of the electronic communications. The most encompassing privacy protection in the UAE is also contained in Article 378 of Federal Law number 3 of 1987 pertaining to Penal Code, which states that any violation of private or familial life of individuals by recording or transmitting the private conversations or capturing or transmitting the pictures of person in a private place is strictly punishable by fine or imprisonment. There are other privacy protections also given in the UAE Penal Code, which states that any person who publicly disgraces the honor or the modesty of any other person without attributing a specific act to the defamed party may also be subject to fines and imprisonment. While not as far-reaching, there are also privacy protection enshrined in UAE Constitution, which states that there is a general right to privacy with respect to communication, whereby post, telegraph, or any other means. And the penal code also prohibits the misuse of confidential information. Also, it criminalizes the evasion of privacy, theft, defamation, or publishing any illegal content using any electronic or e-commerce platform. Then comes the law on publishing. So basically, Federal Law number 5 of 1985 has been relating to publications and publishing of any article. So as per section 79 of this regulation, any law or any news or any photograph, any comments that relates to the secrets of the private or family life of any individual may not be published, even if they were correct and if they intend to harm them. No secrets that may harm the reputation of a person, his or her wealth, commercial name, or the publication of material intend to threaten the person, force him to pay money, offer a service to others, or deprive that person from freedom to work should be divulged. So basically, this law prohibits any publication, any pictures that harms the reputation of the person, also that belongs to the personal life of any individual. Next slide. Now let's talk about the DHCC health data law. So the Dubai Healthcare City, a healthcare free zone in the UAE, had also implemented regulation number 7 of 2013, which had repealed and replaced the data protection regulation 7 of 2008, which is also termed as HDPR. So this regulates the protection of patient health information as opposed to the personal data. The HDPR applies to the healthcare professionals working in the DHCC with access to the patient health information, including any of the following, like licensed healthcare professionals, licensed complementary and alternative medicine professional, licensed healthcare operator, approved education operator, approved research operator, licensed commercial company, and non-clinical operating permit holders. So a patient health information is not permitted to be collected by any licensee unless it is for a lawful purpose. And also the collection is necessary for that purpose only. So it should not be used for any other purposes other than for the purpose for which it has been collected. However, they have not specifically defined the lawful purpose in the regulation. Further, the patient health information may only be transferred to a third party located in a jurisdiction outside DHCC if all of the certain given conditions which are being given in the regulation are being complied of. On 6 February 2019, the UAE had issued Federal Law number 2 of 2019, which is basically relating to the use of information and communication technology in the area of health, which is called ICT Health Law. The ICT Health Law applies to all the methods and uses of information and communication technology in the UAE healthcare sector, including free zones. The law is the first federal law, privacy law of its kind in the UAE that has been limited to healthcare sector. So this is basically more relevant to only healthcare sector. It prescribes some 31 articles and its application is wide both in terms of geographical spread and industrial spread. Under the law, the Ministry of Health and Prevention sets out to establish a central electronic health data and information exchange to facilitate the confidential access, collection, and exchange of health data and information within the UAE. The health authorities in each local emirate are empowered to establish their own rules, standards, and controls for their own electronic data. And the health information system, such as a method of operation, exchange of data, information, and their protection, as well as access to and copying of data and information. Also, it creates a central system for data population between the Ministry of Health and Prevention, health authorities, and all those involved with the healthcare sector data information processes. Next slide. So now let's talk about some of the compliances and documentation that mostly pertains to data privacy and security. So let's see like how companies can protect themselves by following these compliances. So first and foremost is to have policies in place which should basically covers the data the assets, the data and information which is being handled, and implement protections that are being proportionate to risk exposures. Further, they should also do a timely and periodic trainings to their employees to recognize and avoid and report any hacking or phishing traps, because there are a number of cases wherein employees are receiving the emails, but because of the lack of training or because of their lack of systems, they get exposed to the phishing traps. Also, they should encrypt the sensitive data and test the protections and security systems in place on a regular basis, along with the trainings. Also, they should implement some strong systems in place that can continuously detect the potential threats and breaches to the cybersecurity of the company. Next slide. Also, there should be some kind of policies and regulations in place in the company, which under which the employees or any person in charge should be employed as a dedicated officer, or a dedicated team should be in the place to oversee the cybersecurity and to prepare a report in accordance with the relevant guidelines, and also promptly reports any breaches to the concerned person. Also, they should be having a plan in place that in case if they face any cyber attack, then how they will going to recover in the situation. And when they are entering into any contracts with any vendor, any customer, any supplier, it should be having a airtight indemnification clauses that can definitely protect them from any future liabilities. Also, now, as per the DIFC new regulation, there's a mandate that whenever they're dealing in any such transactions, the data protection clause should be there in their contract so that they are complied with the regulation. Next slide. So this talks about the management duties for UAE companies. So Federal Law number 2 of 2015, which governs the conduct of the commercial companies in UAE mainland, it imposes some of the duties on directors and managers of the company. And accordingly, they should exercise the best reasonable care and they should act in the interest of the company. And if a management fails to take adequate measures to protect the company from any kind of cyber crime or any cyber attack, then this may be considered as a failure on their part. And if the company is suffering from losses and damages, then the person who is in charge of or responsible of taking care of the operations, or who is a managerial who is involved in these kind of transactions, may face may be personal liable for not performing the duty on time. Management acting in the best interest of the company must also make cyber security as a top priority, and also they should comply with all the regulations that are being in place. Also, they should always the company should always prepare for the risk strategy, develop and enforce the cyber security culture in the organization. And let's see like just a few steps that how they can ensure the cyber security culture: by identifying and assessing the risk, by detecting the threats, developing the policies that can protect them, and also responding to the incidents and having a recovery plan in place. Next slide. Let's talk about some of the penalties that are being given under the cyber law. So basically, for accessing a website, electronic IT means without any proper authorization, in that case, there could be a fine of 1 year or a penalty which range between 250,000 to 1 million. And hindering or obstructing any access to any computer or network or website, in this case, there could be a fine levied between 100,000 to 300,000. In case of deliberately receiving or intercepting any communication through any company network, person can face a fine of ranging between 150,000 to 500,000. Or circumventing any computer network protocols addressing by using a false addresses, a third-party address, then there could be a fine of 500,000 to 2 million. Next slide. In case there is any willful, intentionally or without authorization running of a software on the computer network or an electronic IT system, then there could be a fine of 500,000 to 3 million, plus there could be an imprisonment up to 5 years. Also, using of any communication services, audio or video broadcasting channels or computer networks or other IT means without a legal right, then there could be a fine of 1 year. There could be an imprisonment of 1 year or fine ranging between 250,000 to 1 million. Accessing of any legal right or credit or electronic or number of electronic card numbers or data or bank account by any person, then he could face a fine between 100,000 and 300,000 and 6 years imprisonment. Most of you people must have experienced that, sometimes people are getting called that we are calling from this and this bank and please give us these details. Now, if these kind of any issue arises, and if a person, the subject matter, if they goes and complains, and the person who is doing all these things, they can face a huge penalty under this. Next slide. Then in case of money laundering also, in case deliberately using a computer network, electronic IT systems or IT means to illegally transfer, transport or deposit any fund with the intent to conceal and disguise the resources, conceal or disguise the nature of illicit funds, or attain and process or use knowingly any illegal funds, there could be an imprisonment up to 7 years and a fine between 500,000 to 2 millions. In case there is any breach of privacy by way of invading another person's privacy by using a computer network, any electronic IT system or any IT means, there could be a fine ranging between 150,000 to 500,000 and minimum 6 years imprisonment. Similarly, for medical data also, if there is any obtaining, possessing, modifying, destroying or disclosing without any authorization, then there could be a temporary imprisonment, and also there could be fine on the court's discretion. Next slide. So as we have discussed, there are many penalties which are being given under the cyber crime, and in a world where the technology is immensely evolving at a fast pace, that concerns about the ability of states and government to succeed in protecting the privacy of the citizens have increased. It is not a trend, it is an actual threat that may be caused to harm others, especially with the rise and the integration of such technologies in machines that people use in their day-to-day life. For example, any appliances that is being, any household appliances that is being used, like a washing machine. As a consequence, one may predict that the countries will be more vigilant in addressing the data privacy and building the proper legal infrastructure to ensure that its protection when exchanged or transferred. So on this note, I would like to hand over to my colleague Oliver to take the session further, and I hope this was useful for you. Thank you so much.
Thank you very much, Sakina, for that insight from a legal perspective. I'll now introduce Mr. Madan Mohan, who heads up the cybersecurity and data governance here at MPG, to give some more insight into the practicalities of the regulations in the UAE. Madan, over to you. Thank you.
Thanks, Oliver. Thank you so much for a brief introduction. And thanks, Sakina, for the detailed information on UAE laws pertaining to data protection and cybersecurity. Thank you, Sakina. Hello, everyone. Trust you and your family are doing good and are healthy. In continuity, I will talk about DFC Data Protection Law number 5, 2020, which was enacted by His Highness Sheikh Mohammed bin Rashid on 21st of May 2020. Next slide, please. Next slide. So basically, this law replaces the existing data protection law, DFC law number 1 of 2007. This new law protection has been implemented on 1st of July. However, DFC has given grace period of 3 months, that is until 30th of September 2020, to comply with the new data protection law and to notify the DFC authorities accordingly. This new law will also regulate the collection, handling, disclosure, and use of personal data in DFC. However, DPL 2020 includes enhanced governance and transparency obligation that mirror many of the principles of GDPR. Next slide, please. Now, this is very important thing for the companies who are in UAE and if they are working from the DFC premises. So this new law is applicable to all DFC registered companies, and companies who are not registered but working from DFC premises are also applicable under this law. Next slide. Having said earlier, right, this new law is amendment of previous law and have many major changes. For example, in previous law, DPO, Data Protection Officer, was not mandatory. However, as per new law, if companies are performing high-risk activities, then organizations should appoint DPO. So as per the new law, high-risk activities are the activities if organization using new technologies like machine learning or artificial intelligence to process personal data which might impact data subject rights. Also, if controller or processor processing special categories of personal data, then organization must appoint DPO. Under data protection principle, the new law added accountability principle as well, which further states that every organization must set the roles and responsibility towards protection of personal data. Next slide. As per new law, now controller or processor must demonstrate the compliance of law to DFC Commissioner Office. Under the right of individual clause, few more rights have been added, like right to withdraw the consent. That means organization should provide some kind of provision to data subject so that they can send and consent withdraw request to the controller or the processor. They have also added right to portability clause, right? Which means now organization must provide a personal data in a clear text to data subject so that they can port their personal data from one company to another company. Another right is right to access. Right? Now, organization should provide a data in 1 month's time to the data subject, and that is also a free of charge. Company cannot charge for to giving these kind of data to the personal. So next slide. As mentioned earlier, organization has to demonstrate the compliance to DFC Commissioner, that data subject is providing consent freely and unambiguous. As per new law, controller and processor must enter into a legal binding if they are sharing the personal data of customer or employees. Earlier, if companies were transferring any personal data to outside country, then they had to take permission from DFC Commissioner. But now, as per new law, now controller have to ensure that processor which is outside DFC should maintain the adequate level of data security as well as ensure the legal binding between controller and the processor. Next slide. Now, if you are aware that as per GDPR, if any breach happens, then controller or processor must notify the breach to GDPR authority within 72 hours. But in DPL, they have not set any timeline. However, if any breach happens, then controller or processor must notify the breach as soon as possible to DFC Commissioner as well as data subject. This time, one of the major changes done on the penalty side. Earlier, the maximum penalty was $25,000, but as per new law, this has been increased up to $100,000. Next slide. Now, this is also very much, very important slide from the controller perspective as well as the processor perspective. New law has one mandatory requirement of data privacy impact assessment, right? If organization is processing high risk activities, right? Organization should consider many factors while conducting the DPIA. For example, categorization of personal data. They should categorize the personal data, and also they should consider the volume of data, how much data they are processing, right? And whether these data are accessing by the third party or not. So they should consider those aspects while considering the privacy impact assessment. They should also check the nature of access, how they are accessing. They are accessing directly to the system, or it is through some medium, some application through which they can control the access. Right? They should also consider the number of systems on which they are transferring this personal data. It is only one system or the multiple system across the organization or outside the organization. Right? And there are many factors that, which impact the privacy of the person. Right? Organization must also conduct the risk assessment to identify the major risk towards the personal data. Right? Organization should identify privacy requirement of that region and the company itself, and should conduct the gap assessment to identify what are the gaps, what are the current controls they have implemented, and what kind of controls they have to implement to mitigate the gap. They should also prepare the risk mitigation strategy to reduce the risk, and the most important factor is likelihood factor, right? So they have to consider the likelihood while preparing the risk mitigation strategy to reduce and implement the recommended control. Next slide, please. Organization must consider the privacy by design concept, right? And this is to protect the personal data. Companies should adopt encryption and pseudonymization technique to protect personal data. Pseudonymization is a technique in which data management, it's a data management or de-identification procedure basically, by which personally identifiable information fields within the data records are replaced by one or more artificial identifier, right? So if you use the pseudonymization, then nobody can able to identify what would be the main data. Right? Organization should consider or should ensure, I would say, confidentiality, integrity, and availability of the personal data, and regularly evaluating the effectiveness of the technical controls. They should also adopt the information security standards, just like ISO 27001 or NISA, to improve information security posture of the organization. Next slide. Having said, this time DFC has implemented many penalties from $10,000 to $100,000. For example, if company does not have privacy policy, then there would be a fine of $25,000. If controller or processor is processing high-risk activities without conducting data privacy impact assessment, then there would be a $100,000 penalty. If organization is unable to demonstrate proper technology controls or privacy by design concept, then there could be a $25,000 fine. Right? If organization processing data subject data unlawfully, then it could be $50,000 penalty. And if organization is unable to provide rights to the data subject, then as per the new law, it could be a $100,000 fine. Next slide, please. Yes, this slide is very important slide for you guys, which states about how to get ready for the compliance. Now we know that what is this law, what could be the implication, what would be the fine, right? Now how to implement this, how to get the compliance status. So basically I have divided this in 9 major activities which ensure the compliance of the new data protection law. Next. Now, first is data audit, right? So organization should conduct or should consider, they should conduct the data audit which covers the source of data, from where you are getting this data, right? And what kind of personal data you are getting from the customer, from your employee. how the data is stored, where it is stored, and how long for it stored. Right? So you have to conduct the data audit, and that is the complete data life cycle of the audit. Next slide. The second would be the communicating privacy information policy. Right? You should prepare a privacy policies, right? And controller must review their existing policy procedures and notices and update them in line with new requirement. And important thing is, all notices must be concise, transparent, and easily accessible by the data subjects. Next, please. The third point is data rights, basically. Data right must be provided to the data subject, because there would be very heavy fine if you are not providing data right to the consumer. That is $100,000 fine. And organization should consider how their procedures should change to comply with these enhanced rights. So they should consider what would be the mechanism so that they can provide these data rights to the data subject. Next one. The next is the consent, data subject consent. Basically, organization should review the existing consent to determine whether they would be adequate under the new data law or not. So they have to review each and every consent detail, whether it is implicit consent or the explicit consent, and these should be adequately with new data law. Next, please. That is the legal basis for the processing of personal data. Right? So in this, basically controllers need to determine the legal basis on which personal data is processed and update the relevant privacy notices. Right? So you should not get more data from your customer if it is not required by the law or by the processing of any services. Next, please. Next is accountability. Having said earlier, organization can take a number of steps to demonstrate the compliance, right? And for an example, organization should keep records of all data processing activities that they are carrying out. They should implement technical as well as the organizational measure to achieve the compliance. They should also conduct data protection impact assessment where controllers are engaged in high-risk processing activities. They should also appoint a data protection officer if processor or a controller are engaged with high processing activities on a regular basis. And another one is the implement. They should implement the measure. They implement measure to meet the principle of data subject by design and by default. Right? Including they should implement the data minimization technique, pseudomization technique, right? Transparency, the data should be transparent to the data subject, and improving the security feature on ongoing basis. Next, please. Right? Yes, so this high-risk processing activity, controllers or processor should identify the high-risk processing activities, and accordingly, they should make a strategy to protect the data and comply with this law. Next. Data breaches. Organization should prepare the incident management policies, breach procedures, right? Information security policy and a privacy policy as well. So the documentation is very much important, and that should cover the data breach. Next, please. Yeah, this is the last one, but this is very much important. The legal contracts. The controller should review and update their contracts with the processor, with their employee, with the third party. Next, please. Yes. Now we know that what the new law is, what are the requirements to comply the new law, and what are the penalties towards the compliances, non-compliances. MBG is supporting existing and new clients to comply new data protection law with an objective of and to improve overall data security posture of an organization and avoid penalties towards non-compliance. We provide this solution in 3 phases, basically. Right? In first phase, we conduct as-is assessment, right, and provide compliance audit report to the customer. We review organization existing policies, procedures, and practices towards information security and data privacy. We also review complete data lifecycle and identify gaps in the processes. We review their existing legal documents signed with their existing vendors, processors, or the employees, and find the gaps, whether these existing clauses, existing contracts is as per the new law or not. Then we submit our compliance report with our expert recommendation to mitigate that risk. And so this is the phase one where we provide the compliance report, the gap assessment report with our recommendation. We also assist organization to filing the compliance on DFC portal. On the second phase, basically, we prepare all documents which are mandatory to comply with the new law, like data privacy policy, data breach procedures, incident management procedures, consent documents. Right? We also create legal documents like employee and third-party contracts. We conduct end-to-end privacy impact assessment and provide trainings to the employee. In phase three, basically, what we have seen that companies doesn't have an internal team to conduct this exercise again and again, right? And we provide virtual DPO service in which we conduct a regular assessment and update overall security posture of the organization. And we also had them for the
particular cases. So we'll probably contact directly on that. There are some more general questions around data regulations, which we'll field now. If I can just pull those up. So one of the questions is relating to DIFC. What will happen when an IT employee working in a DIFC company leaves the office and does not provide the information to all of his successor? Quite specific, that one, but perhaps Madan, you can address that.
Hi, Oliver. I will going to take this question.
Sure.
Yeah. So basically, as per DIFC regulations, and also now there has been more obligations being put under the new DPL law. So an IT employee, if they are leaving the company, that person should provide all the information to his successor when he is leaving the company. And in case there is a failure on the part of the employee, then that employee can face a huge penalties. So basically, there was a recent case in DIFC, and in this case, the court had decided that when when companies IT gets sabotaged because of the failure of the employee's proper handover details to his successor, then the company was being claimed, and then that company had claimed from the employee a huge amount, and he successfully got it. So this amount was approximately US dollars 690,000, which is a very huge amount for employee to pay. So all these care should be taken when a person is leaving, and when the handing over especially has been done upon leaving the organization. Thank you.
Okay, thank you. And Sakina, perhaps you can clarify this. There's another question regarding to taking pictures and images. And if you can clarify this, if it's considered a crime when taking a picture and publishing, there's a bit more information, but that's the broad message in the question.
Correct. So basically, I'll just rephrase the question. Issue of taking the pictures is quite confusing. Is it considered as a crime when a picture is being taken of an attacker or aggressor, and not publishing it, or is it the criminalization is on the act of publishing only? So basically, for taking the pictures, there could be two aspects. When they are taking the pictures which are being specially prohibited, then definitely that could considered a crime while taking the pictures. But while publishing, most of the regulation broadly what it says is that when you are publishing any picture, any data with respect to any subject matter, then it is always better to take consent from that subject matter. So when there is a consent, then that would not form the act of the criminalization. That would be more on a kind of the, that they have duly obtained all the authorizations and then the pictures has been published.
Okay. And with regards to DIFC, I know this was mentioned in one of the questions earlier, but it's an interesting analysis. So if the company is not registered under DIFC, but working from DIFC premise for a company, an insurance company, to process the company's personal data, are they applicable for the new DIFC law? Perhaps, Madan, you can address that question.
Yeah, Oliver, I will take this question. Yeah, this is a very important question, and many companies who are registered, who are not registered under DFC, but they are, taking personal data of their customer and processing to improve the quality or maybe giving some services, right? So yes, if your company is working from DFC premises and processing customers' personal data, then your company would act as a processor, right? And it is mandatory to follow and comply new law. Also, you have to demonstrate as a processor to the compliance of this law to the DFC commissioner officer.
Okay, thank you. And one last, I think in the interest of time, we'll need to wrap up. With regards to the legislation that complies with GDPR, can you just clarify? I think, Madam, that the DIFC regulation very closely aligns to GDPR, and GDPR becomes the benchmark for a lot of countries' data protection. Apart from DIFC, is there any other regulation, legislation that complies with GDPR in the region?
So in this region, as Sakina already mentioned, that there are not a single legislation or single law for the data protection, but there are a combination of different law which talks about personal data protection, right? But apart from DFC, for DFC companies, there is nothing, right now which talks about the personal data. So there is no single law in the UAE which talks about personal data.
Okay, thank you for clarifying. And perhaps one last question again on DIFC. Which industries are part of DIFC registered companies? Is there any criteria to be registered in DIFC? Perhaps, Sakina, if you can address that.
Yeah, sure. I'll answer this question. So basically, it is not very specific relating to data protection or cybersecurity. However, with regards to industries, there are many industries. Mostly DIFC is a financial hub. So mostly financial institutions or branch of banks, branch of insurance companies, those are registered in DIFC. However, broadly it is categorized as a regulated and non-regulated entities. So financial related institutions all comes under the regulated, others are under the non-regulated entities. And the criteria for registration is basically, it depends on what activities a company is conducting and what is the requirement. And definitely if anybody is interested in registering in DIFC, we can support them from end-to-end services, plus we can help them in compliances also in DIFC. Thank you.
Okay, thank you. I think in the interest of time, we'll wrap this up. There are other questions which have come through which are very specific. What we'll do, ladies and gentlemen, is reach out to you directly on those and get those addressed for you as soon as possible. I appreciate it's an area which is relatively new to the UAE. So there's a lot of clarifications which are required, and we'll happily help where we can. And what's clear, as both of the speakers have alluded to, is the fact that these type of regulations are only going to increase over time. The DIFC is probably the first, and we'll see a lot more compliance measures as the UAE grows into a more and more mature market. So it's a subject of great interest to everyone. That's it from today's webinar. I'd like to thank both Sakina and Madan for their valuable contributions. We'll leave our contact details up at the end. If you have any questions, please do let us know. But in the meantime, ladies and gentlemen, thank you very much for your attendance. And we will keep in touch and keep you informed of any forthcoming webinars and MBG events. We try and service the community as much as possible, with webinars being the primary method of that at the moment, obviously. So that's it from me. Thank you very much for your time, ladies and gentlemen, and have a good week ahead.